Hi, welcome to Get Used to It. I'm your host, Sheila James Kuehl, and today we have a wonderful panel to discuss issues that I think people are talking about all over the country, and that is the panoply of legal issues that are facing our community for better or for worse. And you'll see why for better or for worse is actually one of the legal issues that's facing our community. We're talking about marriage, we're talking about discrimination, we're talking about employment, and just a number of harassment issues, current issues for our community. I have a wonderful panel, as I said, and I'd like you to meet them. First, Taylor Flynn, who is the attorney at the Southern California ACLU who works on our lesbian and gay issues. Welcome, Taylor.
Hi, thanks.
The mayor of West Hollywood, John Heilman, who is also a law professor at the Whittier Law School here in Los Angeles.
Hi,
Welcome,
Sheila.
John. And Carmel, Sella, who is the new co-president of Lawyers for Human Rights, the Gay and Lesbian Bar Association of Los Angeles, the bar association with the longest name of any of our bar associations. And Carmel is also the legislative deputy for Los Angeles City Council member Mike Feuer. Welcome, Carmel.
Hi, Sheila.
John, I want to talk to you first. There have been fora all over the country about the issue of gay marriage. And the reason I think this is happening is because, as we've all heard, something is happening in Hawaii about this. Could you tell us kind of what's going on?
Well, in a case in Hawaii, the Hawaii Supreme Court decided that not allowing gays and lesbians to marry constituted sex discrimination under the state constitution. And they said that the state had to show a compelling state interest in order to justify this kind of discrimination.
Now that's really different in a way, because I'm sure that most people think if they don't allow us to marry, it's discrimination based on sexual orientation. How did they come to the conclusion that it was sex discrimination, which is already unconstitutional in every state?
Well, the reasoning of the court was that if a woman can marry a man, why can't a man marry a man? And by differentiating in that way, you are discriminating based on the sex of the person who wants to marry. And that is the reasoning that the court has agreed with, and it now has gone back to the trial court level for the state to try to develop some kind of compelling state interest, which most observers are saying the state's not going to be able to do.
Now the legislature tried to pass something in the interim once the Supreme Court said, you know, we think this, we declare that this not giving marriage licenses to same-sex couples violates gender discrimination. Now you have to find a compelling reason for the state with the very highest level. So the legislature got quite panicked in Hawaii, didn't they, and tried to do something.
Yeah, but this is a constitutional issue. The legislature would not be able to just pass a bill. They would have to do something that would amend the Constitution of the state of California.
Of Hawaii.
I'm sorry.
We'll get to California
Hawaii.
next.
I'm thinking about what the legislature is trying to do here in California. I don't think there's support for that. In fact, the governor just appointed a commission in Hawaii to study this issue. The commission came back with a report that said the best thing to do here is to recognize that gays and lesbians have the right to marry as well. And that commission report is going to be very powerful evidence when this does go back to trial that there is no compelling state interest involved in discriminating against our community.
But there's such moral certainty in the voices of people saying that this is, you know, such an abomination and such an ahistorical and amoral thing. But to me it sounded very familiar. Not that I was alive around the time of the Civil War, but it seems as though in every generation there has been some disfavored class that has been not allowed to marry. Why is this such a powerful tool and that's being used?
Well, I think it has to do with us as human beings. If you can prohibit us from marrying and having loving relationships, if you can trivialize the relationships we have and not give them legal sanction, then you're saying that we're somehow less than everyone else. And I think that's why this is a very important issue for many people in the community who don't themselves want to get married, but they feel that there is some kind of discrimination that really diminishes us as human beings by saying that our relationships don't count. And you're right, you don't even have to go back to the Civil War. You can see during this century restrictions on immigrants being allowed to marry, restrictions on African Americans being allowed to marry whites. I mean, that we now look back at that and think that's so silly. How could we have ever have thought that? But in fact, that was the argument that was made, that somehow this was going to taint the blood supply, and what about the children, and all those arguments that were made back then now seem so foolish. I think the arguments being made against us are going to seem pretty foolish in about 20 or 30 years as well.
Well, I think it's optimistic, but I believe the same, because slaves weren't allowed to marry. And then, as you said, all the way up into the 1960s, in some states, African Americans weren't allowed to marry whites. And the ringing declarations about how this would just bring civilization down around our ears. I mean, the word ridiculous or silly, it's true, but the power of it and the destructive nature of it, and the attempt to render our own relationships invisible, because it's so circular. You can't get married, therefore you are unstable in your relationships because you can't get married. I mean, it's the imposition of it, seems to me, is very powerful.
Well, it does destabilize the relationships that people have in the community. There are a lot of pressures that are brought to bear on heterosexual couples who are married. You know, you hear the arguments they should stay together for the children, and there's a lot of family pressure. Both families sort of come together to sort of encourage the marital relationship. Our relationships don't have that kind of encouragement a lot of time, and they certainly don't have the legal sanction. So it's much easier for people to break up in our community, and I don't think that's necessarily a good thing. I think that relationships are good. I think that's why so many people in our community want to get involved and get married. They want to have that permanence and that sense of really belonging to one another for life.
And we do it against all the odds too. I mean, against more odds, because our relationships are not encouraged. And as a matter of fact, many of our families just totally freak out. We're asked to hide them. We can't have the picture on the desk. We can't bring them home for Thanksgiving. A lot of pressure on us not to be in those relationships. And it seems to me that this lack of the ability to marry is yet another way to say you must not be in those relationships. You will never be happy, which is what a lot of parents say. And the use of the law in other states, like now California, where an attempt is being made to declare that if and when marriage between same-sex couples may be legal in Hawaii. One of my colleagues across the aisle, Pete Knight, has a bill that would declare for California that those marriages would not be valid in California. Can they do that?
Yeah, I mean, there's a legal question about whether they can do it, but historically states have had the power to determine whether or not to recognize marriages in other states if those marriages are against the public policy of the present state. So California might say, we're not going to recognize marriages that are entered into in a foreign country where you could have a polygamous marriage. California might say that's against the public policy of the state of California, and we're not going to recognize it. And in fact, during the days when interracial marriages were being prohibited in certain states, there were states that said, you go to another state to get married, if it's against the public policy, we're not going to recognize it when it comes back here. There are going to be some big legal battles, and law professors all over the country are already looking at where the test cases are going to be. Just came back from a law professors conference, and it's not just members of our gay community that are interested in it. This is the hot topic for family law professors, con law professors throughout the country. This is the cutting edge issue in terms of civil rights in the 90s.
Well, it's because it takes full faith and credit, which requires that all states recognize the laws of other states, and carves out a very specific exception in California. I mean, we don't allow first cousins to marry, but if they do marry in Georgia, where it is allowed, we recognize those marriages. And there are a number of other instances of marriages we would not allow here, of people who are underage without parental permission, for instance. But when they happen in other states, they're valid marriages here. And the chaos that would be created, you know, I go to Hawaii to work for X corporation, and I'm married in Hawaii. X corporation transfers me to Los Angeles to their other office. I have medical benefits under the law in Hawaii. I don't here. It's quite chaotic, and frankly, it's only, I think, homophobic.
Oh, absolutely. I mean, this isn't anything to do with marriage in general or recognizing marriage. This is clearly directed at our community, and it's not just in California. Other state legislators are trying to do the same thing, where they will affirmatively prohibit gay and lesbian marriage in their state, and furthermore, they won't even recognize it if they enter into it in a state where it is lawful. That's why law professors are looking at states where there is no express prohibition on same-sex marriage, and where the laws with respect to marriages from other states are fairly liberal and are willing to recognize out-of-state marriages. So those are the sort of places where the challenges are likely to be made, and surprising the states. It's not always what you would perceive as the most liberal or the most gay-friendly states that have at least marital laws that are fairly supportive of recognizing marriages from other states.
Well, Taylor, you've got an interesting case right here in Los Angeles. It's really an employment case in a way, but it seemed like it had really far-ranging effects. Can you tell us?
Yeah, well, it does have far-ranging effects. There is an openly lesbian police officer, Virginia Acevedo, who had filed a suit against the LAPD for sexual harassment and for discrimination based on sexual orientation. And when she was deposed by the city attorney, he asked her an astonishingly broad and intrusive question. He wanted her to name every single person she had ever had a sexual relationship with during the entire course of her life. And when she refused to answer on privacy grounds, they filed a motion to terminate her benefits. So effectively, the city of Los Angeles was holding her benefits hostage on the condition that she out other people. The city attorney and the LAPD had reason to believe that she had been in relationships with other people in the LAPD, and my sense is that they were trying to not only harass Ms. Acevedo, but to nose around and get embarrassing information on other officers. And so we stepped in and filed an amicus brief on behalf of the unnamed individuals, and basically saying this is blatantly unconstitutional. It violates their First Amendment right to freedom of association, as well as the right to privacy.
Now, do they do this with straight people too?
You know, it's a problem only for lesbians, gay men when they're plaintiffs, and women. Women when they file sexual harassment claims, sexual assault claims. And it's really a case of victimizing the victim. When you have someone who comes forward and says, I was sexually harassed, sexually assaulted, then suddenly the door is flung wide open and questions about your personal life and back, you know, yay so many years suddenly appear. And I do not know of cases where this sort of questioning occurs for straight men. And it occurs routinely by the city and also by private corporations when lesbian and gay men are plaintiffs.
Well, it's interesting to me because the characterization of women always has some connotation about your usefulness as sex objects or partners or whatever. Certainly when people talk about our community, since the only thing that distinguishes us essentially, I guess, is the gender of the person with whom we have sex, at least that's what most people think, our community is sort of all about to other people sex. So all the questions about that are about sex, but with straight men, when they have employment complaints or whatever, I guess it's not an issue. It's not a way of harassing them. It's not supposed to be something they're doing wrong.
Right.
Whereas, of course, women are doing this wrong and gay people are doing this wrong.
Right, and I think the problem was so extreme that the federal rules of evidence and the California rules of evidence specifically addressed this issue and said you cannot ask for the past sexual history of someone in these kind of cases, sexual harassment and assault cases, except within very narrow exceptions. And in this case, the Los Angeles City Council reacted very quickly. We got a very positive result. The city attorney came to an agreement with the city council, agreed that the questioning was overbroad, as he basically was forced to, agreed to not terminate Ms. Acevedo's benefits, and to do training for all city attorneys in the workers' compensation area.
So was this an overly enthusiastic deputy city attorney? Or overly homophobic? Or
I would say if you read the deposition transcripts that the city attorney who asked the questions seemed to me to be homophobic. And the reason I say that is that when Ms. Acevedo objected and her lawyer objected, he constantly said, well, you're suing the city because you're claiming that people called you a dyke and a fag, and he kept repeating all sorts of offensive terms. And it seems to me that when he did that repeatedly, rather than try to find another way of stating the matter and saying, well, this claim is based on a sexual orientation discrimination claim, that there seemed to be a real edge to his questioning. And I can't get into somebody else's mind, but it definitely seemed like Ms. Acevedo was being targeted because she was a lesbian.
so do you think that this is going to go away, or have you seen this sort of line of questioning notion? I mean, there was something in the paper about how there was a stress claim, and I don't know whether this is accurate or not, but that they were trying to justify these questions on the basis of this fishing expedition.
Right.
That, well, maybe somewhere out in her history there was some lover who had made her feel stressful.
Right, right.
Although, you know, in family law we're not allowed to bring that in because they assume they're going to make you feel stressful.
That is their claim, and they can ask her certain limited questions. Instead of saying, go back and name every single person that you'd ever had sex with, you could say, ask the very limited question of, have you ever been in a relationship that caused you stress outside of work? And then go from there. But
so it would be a slightly shorter list.
it would be a much shorter list, I would hope. I would hope.
Because you have to be really serious with someone before it's stressful, right?
Right, right.
Well, so have you seen any evidence that there's going to be a change in terms of how the city attorney, at least in LA, is going to handle this stuff?
Well, it's too soon to tell right now. I certainly hope that there will be a change. And now that we have the city attorney's office on record agreeing to change their policy, if there are further problems, it will be easy enough for us to bring any complaints to the city attorney's office without having to litigate, I hope.
There's an extra problem, I think, where this impacts our community. It's insulting enough to say to a woman, well, you claim you've been sexually harassed. Why don't you tell us everyone you've ever been sexual with, because then we can see if you're so promiscuous that you've opened yourself to harassment. That's supposed to be the theory.
Right.
At least if you're forced to name your, if you're a woman, your male lovers, it doesn't necessarily name them as anything except, I suppose, desirable
Exactly.
males. Problem for our community, of course, is that in addition to the insult of having to name people for no relevant reason, you're outing them, which
Right.
you mentioned before.
Right, and that's a big problem because there's so much harassment and discrimination that goes on, even though that's illegal in California. By naming these individuals, Ms. Acevedo would have been putting them at risk for being harassed, for possibly being fired from their job, for being subject to physical violence. And there's a whole host of horrible things that could happen that are specific to being a member of our community that makes it particularly egregious that the city was asking these questions.
Well, we're usually kind of at the mercy of the chief prosecutors in any particular political entity. And Carmel, I want to talk for a minute about the chief prosecutor in the state of California, Danlundgren, who has been responsible for a number of cases that our community's been concerned about. It reminded me when Taylor was talking about this over-enthusiastic deputy of one of the cases, which was also, in essence, an employment discrimination case. Can you tell us a little about it?
Here is an example of the power of the written word as opposed to a deposition, where you had a kind of low-level staff attorney, apparently, who wrote a brief in a military case. A lieutenant in the National Guard had come out to his commander, and he was terminated. And he sued, saying that don't ask, don't tell was unconstitutional. So the attorney had straightforward arguments. There's no liberty interest, there's no violation. But he took the opportunity to say, and by the way, there's no protected class, there's only homosexual desire. There was a subtitle saying, you can itch, but you can't scratch.
In the brief?
In the brief. And it is so extraordinary to have language like this in a brief, and at one point said, it's still okay to discriminate against criminals, child molesters, pedophiles, and it's still okay to fire them. And the state attorney general kind of had it two ways. He said, I didn't see the brief, I didn't write the brief, but I'm not going to take the lawyer off the case. It was only when it made the press and our community kind of was focused on it that he did finally decide to do that.
Well, I understand even, this was a, if I'm not mistaken, this was a federal case. They used to say, don't make a federal case out of it, but actually it's good to make a federal case out of it. And the district court judge was so offended by the language in the brief that had been filed. Because, you know, when you file a brief, you're supposed to be briefing the legal issues. You're not so, wasn't there, there was something else in it where he said, you know, that the National Guard doesn't exist in order to protect this lieutenant's nasty little habits.
Right, and his uncontrollable habits, and that rather than be someone with a legitimate claim, he was just irked that the state didn't recognize his uncontrollable desires.
So at the same time, this Deputy Attorney General was sort of castigating our community and trivializing the whole notion of discrimination against us. But it did have a very smarmy, nasty tone to it, and as I understand it, the judge was so incensed that Attorney General Lundgren was forced to A, take the guy off the case, and B, write a letter of apology to the judge, which I'm sure he wasn't too happy to do.
That's right.
Well, it was interesting to me that he said, well, I haven't seen the brief, and you know, maybe it went a little far, but not so far. And I suppose we could cast that off in terms of whether we feel Mr. Lundgren is with us or against us. But there have been a couple of other examples that have sort of mounted a record for his office.
Absolutely. It's a real pattern of the state going out of its way to really persecute our community. There was a case of entrapment at an adult bookstore, and I understand that it wasn't a gay bookstore, but they only went after gay men. And according to the court, the police department put in very attractive young police officers who would kind of walk around making eye contact and really pulling people in, and then they would be charged with solicitation of a lewd act, whatever that is. And the court threw out the conviction saying, A, you didn't target other people, you just went after gay men. You can't do that. And on its face, it's discriminatory. The Attorney General said, oh no, you know, we had no intent to discriminate, and even if we did, it wasn't arbitrary. There are legitimate reasons to go after these people. And now the Attorney General has gone so far as to appeal to the California Supreme Court. And not only that, went to the appellate court and said, in case we don't get granted review, this case should be depublished, meaning it shouldn't have precedential value.
Because the court said that the prosecution was in the wrong. I mean, the basic notion of prosecution, and I think if you walk down the street, any street, stop 10 people and say, if 10 people commit the same crime, do you think they ought to be prosecuted the same way for the crime? And they would say, exactly the same crime? And you would say, yes, and they would say, yes. So selective prosecution has always been one of those things that we don't want prosecutors to do. And one of the ways that we get them not to do it is we throw out the conviction if they do it. That's sort of the basic tenet, I think, right, of the selective prosecution. And so the court said, hey, this is the law. It's been the law for a long time. You did this. Conviction goes out. So now Danlundgren is appealing that to the state Supreme Court and saying, and if I lose, I don't want you to publish the opinion from the lower court, because then there'll be some precedent about selective prosecution in these matters, and I don't want that to appear.
And what's really troubling is that, you know, you always hear about scarce resources. The state doesn't have money to do this, doesn't have money to do this, and then they're spending all this effort and money on these cases, and it just shows what their values are.
Well, that's two.
But the best is the last, is in the Colorado case, Amendment 2. And some people are very familiar with that, but that was a state initiative in Colorado that was passed by a narrow margin, about 53%. And it said that all protections for gays and lesbians are void because just because. I'm not even sure why.
Because they shouldn't have special rights. Right. I remember that.
When really all it was
campaign.
protections, having everyone on a level playing field. They're saying that it's special rights. The Colorado Supreme Court invalidated the state initiative, saying you can't just go after one group, and it said that the Equal Protection Clause protects that group.
So wait, let me understand the basis of it, just because there are people all over the country, fortunately, that watch us and may or may not know. Some of the cities in Colorado, like cities here, what cities, for instance, in California, they have
Los Angeles, West Hollywood, San Francisco, all have
essentially say you cannot discriminate against people on the basis of their sexual orientation, as well as a lot of other categories. And I guess Aspen had this, and Denver, and the state initiative that was passed by the people by a very small percentage said you can't have those kinds of protections in your cities or counties, right? You cannot pass a law barring discrimination against gay and lesbian people. That was, okay, so that was sort of like we had a fair housing thing in California a while ago. It was called fair housing, but it was anti-fair housing, that said you cannot have fair housing laws in California, and that we had an initiative, and that was thrown out. And in the same way, this is sort of an anti-equality initiative, and the Colorado Supreme Court said you can't do that. But they used some very general language in their opinion, didn't
Any
they?
identifiable group, and people have really taken that to an absurd degree and said, well, that means that blue-eyed people have special rights, or that you could not fire someone because of their hairstyle, or anything, and that...
Well, and it created, apparently, at least in his mind, a serious problem for Danlundgren, who then joined an amicus brief on behalf of all the people of California, asking that Amendment 2 be upheld in the United States Supreme Court.
And what's interesting is that 44 states didn't have a problem with what was happening, and we're going to wait for the Supreme Court to rule. Only states like Idaho, Nevada, South Dakota, Virginia, not really a consensus of states, and not states like California. So again, it's very aggressive on the part of our Attorney General to make this action. And he was saying, well, I need to, because I need to enforce anti-immigration laws, which is not something we want.
Yeah, let's explore that for a minute, because I actually was angry enough to call Danlundgren and was patched through to his car phone, which is one of the wonderful things about being a state assembly member. They go, just a moment, I have the Attorney General on the phone for you. And he did say to me, no, this is not homophobic. It's because I'm required to, as the state Attorney General, uphold Prop 187 and the anti-smoking laws. And that the language of the Colorado Supreme Court saying you cannot single out an identifiable group to deny civil rights is a threat to those laws. What do you think?
Well, I think that Prop 187 has basically just been thrown out as unconstitutional.
So he's right. It would actually interfere pretty directly with his ability to enforce 187.
I think it does. I think it would interfere with 187 because that was blatantly unconstitutional, picking out an identifiable group of people and saying they don't have health care benefits, they don't have a right to an education. But things like anti-smoking laws, those wouldn't be affected. It seemed to me that the Attorney General was saying, oh, well, this is about states' rights. And it's not about states' rights, it's about equal rights. And what the Amendment 2 case did was make lesbians and gay men second-class citizens. And that's what Prop 187 did. It made immigrants second-class citizens. So to that extent, he's right. But that's something that's unconstitutional and that the Supreme Court has said you can't do.
What about smokers, though, John?
Well,
Or what do you think?
I just think that, I mean, whatever we think about Danlundgren's political position, he's not a stupid guy. He knew that weighing in from California on this issue was going to influence the Supreme Court, and he knew that it was going to cause a negative reaction in our community, a strong negative reaction. So why did he do it? I mean, you have to think about why would he, as a political person, do that? I think the reason he did it is because he doesn't care about our community, and this is part of a pattern and practice not only against our community, but these really are linked. He's right to acknowledge that there's a linkage here.
But
I mean, it's a linkage in terms of being not only against our community, but against the immigrant community. This is part of something bigger than just a single case, and he knows it, and I think we know it too. This is about him advancing a political agenda that is an attack on minority communities.
But as our Attorney General, he doesn't have that discretion not to care. I mean, his job is to enforce laws that are already on the books, anti-discrimination laws in employment and housing, and he's just saying, oh, no, I'm going to focus on something else, and I don't see how he can do that.
Well, it's even worse than focusing on something else. I mean, not that 3 cases out of all the hundreds that there are builds a great record, but it was really interesting to me, after the first one, then the second one, and Amendment 2, there seems to be, it's not that he's ignoring us, it's quite the opposite. It's that there's a focus in that office on making certain that no matter what kind of legal issue comes up that affects our community, we shall be kept in our place. We will be second-class citizens. We will not be protected from discrimination. And it seems like a sort of an affirmative agenda, which makes it political, I guess, but it's also interesting to me, and one of the things I wanted to ask the 3 of you to talk about a little bit is, we've chosen, all 4 of us, to be lawyers because we think that the law itself is some important thing in the larger context of things. I mean, all of us are activists in our own way, activists for the community and with it. Why is the law such an important thing that everyone is struggling over it? We want to own it, they want to own it. I mean, what is it about the law that is so powerful?
I'd say that some of it is the power of the law to enforce things that are clearly protect individuals' rights at a time when the general population doesn't want to protect their rights. It was the Supreme Court that decided that interracial marriage was illegal. There wasn't...
Was not illegal.
Right, I'm sorry, was not legal. There wasn't that sort of grassroots support in various states that had made interracial marriage illegal to overturn that. And the law is very powerful because you have some sort of combination of, I think, a real moral force and the power to protect groups, minority groups in particular, when the majorities would just walk right over them.
So it's a way, in other words, the law gets in the way of keeping people in a second-class place. I know that in the stories that I've heard about Nazi Germany, it was very important to dismantle the courts, dismantle the use of the law, take over the law so that discrimination would be more legal and there wouldn't be any protections. So that's one aspect where the law is powerful.
But I think that some of that is what you're describing is going on now. The tremendous attacks on lawyers and the legal system in general, the tremendous attack on government that we've been living through for the last 15 or 20 years, as if government was the problem that is is creating poverty and discrimination and creating economic problems. That government is the solution, I think, in a lot of ways, but there are very powerful forces in the country that are trying to attack the whole system of government and attack the legal system as well. And those are the people who stand to gain for when you don't have a legal system, when you don't have any ability to get into the court, or you don't have a court that is able to hear your claim. The people who are going to be benefiting are a select group. They're generally going to be wealthy. I mean, the attacks on the legal system, a lot of it is coming not from conservative, not necessarily from conservative religious right people. A lot of it is coming from corporations that don't like the products liability laws and don't like being held accountable for pollution and other sort of things. So I wish that people could see through it more frequently. I mean, I think we all fall into the trap of blaming government for everything, and the law really has a powerful role to play, not only in protecting groups that are discriminated against, but in protecting individuals who are harmed by products or harmed by pollution. Those are the sort of things where if you didn't have a legal system, where would you turn to? I mean, you'd have anarchy.
Well, it's also a statement, and I guess it always has been. I mean, from the Bible itself is a statement of law, both the Old Testament and the New Testament. It's like rules to live by. But why do we have this body of rules? Because it's an expression of, really, of ethic or moral. That is, the good society is the society that obeys these rules. So the struggle over the law is like a struggle over a declaration about what is moral. And that's, I mean, I'll tell you, when I was testifying against Mr. Knight's bill, the anti-gay marriage recognition bill, or whatever you want to call it, you could see that it was all about a struggle for the high moral ground on whether there will be fairness and equality, or whether there will be a demonization of those people, meaning us, who are not like us. And I think the law has always been in the midst of sort of that struggle. I mean, that's why I wanted to go to law school. It just seemed like being in the middle of it.
But maybe when we all started in law school, we had aspirations about justice and a sense of the purity of law and Thurgood Marshall and all these really fighters, do-gooders. And now I think, I hope our community doesn't abdicate our role here, and that we hang on to these tools and really learn to use them. Because if we give up, then they win. But it's hard when you see all these cases and law really oppressing and really being so used as a sword against us in a very real way.
We're not going to win every case. I mean, when you look at history, I think the African American community had to go through a lot of cases that were not winners, and where the law and the legal system was used as a source of oppression, not as a source of liberation and freedom. But I think time is really on our side. When, you know, I think back to when I was in law school and the very few numbers of openly gay students and very few openly gay faculty members, and many of them wouldn't even teach issues involving gay rights. Now in law school I see very open, active gay and lesbian students and professors who are teaching issues that are of a concern. And it's not just gays and lesbians who are interested. There's a lot of even conservative straight students who think discrimination against gays and lesbians is silly, it's outdated, and are willing to weigh in on our issues. I think the trend is only going to be in favor of us.
Well, and the connection, too, between the issues that we face now. One of the leaders of the NAACP here in LA said to me, well, your community is in the middle of the griddle now. and we are. And I don't think we're just sort of the flavor of the decade. I think it is that moment in our struggle when we are kind of in the spotlight. You know, so many movements pass through a kind of a spotlight period, and we're definitely in it. But when you mentioned Thurgood Marshall, there are two books that I thought were, you know, among thousands that are were very helpful to me. One is the biography of Thurgood Marshall, which is called Dream Makers, Dream Breakers, that documented the work that he did early on. People always think Brown versus Board of Education, you know, they filed a case, and boom, discrimination was over. But 35 years before that case, he was traveling around to various states to file suit against school boards and having to hide out from lynch mobs and staying with families that were in danger of having their houses firebombed because he was staying there, because they knew if the law was going to be used, that was going to be real dangerous to discrimination, to use that tool. And there's another book called Liberty and Sexuality, which is by the same guy that wrote the biography of Dr. Martin Luther King, which is a documentation of the anti-contraception, pro-contraception, anti-abortion, pro-choice movement sort of through the law from the late 19th century. And it really does show really the power of living in a country like this where the law is a double-edged sword. They try to use it against us. We come out and use it against them. And I think that the visibility of our community in these issues is important. I mean, you must know many, many more groups, organizations, people who are working on these issues who are out as members of our community. Lambda, for instance.
Mm-hmm. No, I think it makes a big difference too, putting forth arguments when, as an openly gay, lesbian, or gay man, as a lawyer, because it really confronts people with the reality of who you are. I'm like you. We're having a conversation about these issues, and when you're saying things that are discriminatory, they're affecting me personally. And I think that the fact of having people come out, especially in the past decade, has made an enormous change in people's awareness.
Does it make a difference to you in court? I mean, can you...
Your sexual orientation follows you into the courtroom. It does. And you, in almost any case where somebody's sexual orientation is at issue, you have to file friend of the court briefs that debunk all of the myths about homosexuality. We're not child molesters, we're not emotionally unstable, we're not this, we're not that. And you have to affirmatively take all the stereotypes by the hand and go through them one by one and put them in front of every judge in every single case. So there is no escaping it, but I think that as we educate people, that's going to become less and less necessary.
Yeah, I think there's going to be fewer, in the future, you're not going to have to do that as often, because I think there are more and more people, as you were saying, who are out. And so judges and other lawyers, they know we're not child molesters. They know that we're not emotionally stable, or at least no more emotionally stable than anyone else.
Right.
Right. So I think that's those kind of myths out there. Mm-hmm. Ultimately, because of the large numbers of us who are out and open, that's going away. I think already, as I said, even conservative students who I have, who are very conservative on political mm-hmm. issues, think sexual orientation discrimination is just foolish because they've had too many friends and colleagues who are.
I know there was a survey, I think, of students, I can't remember if it was at UCLA or a number of universities here in Southern California, that asked them about the gay marriage issue, and 72% said they thought it was fine. And that's a major difference, mm-hmm. From just a generation before. And that's it's just a matter of familiarity when you say it. I think it's just a matter of time. Still, though, mythology is another powerful tool. You create mythologies about the demonized subclass that have to, and then you have to actually file a brief going, no, we're not like that, and we're not like that, and we're not like that, and here's documented proof, that straight men are actually child molesters much more than we are. Mm-hmm. We had great testimony from Lori McBride, who is the executive director of Life Aid's lobby in Sacramento on this Pete Knight bill, where she said actually the community with the lowest, or the group with the lowest percentage of STDs, of sexually transmitted disease, lower even than newborn babies, are lesbians. Therefore, she said, if we really want to eradicate these diseases, we should all become lesbians. You should have seen the faces on the panel. They were like, I don't think so. But It was a good point.
You know, you talked about myths, but I wonder if our community also collides against kind of American old-fashioned myths. When we were in the military debate, you had the myths associated with the military. And now with marriage, it's the myth of the family. And I don't know if we've figured out how to reconcile that. You know, it's kind of clashing myths.
Now, when you say the myth of the family, do you mean the myth that there is such a thing as a traditional nuclear family and that that's
traditional,
what everybody is but us?
Exactly, and that we're on the outside, and once we're in that wonderful zone, we'll be in whatever one wants. And somehow that becomes magnified so that our struggle to get inside becomes all the harder. And so I wonder if our task isn't also to say, let's look at what the family is. What is American family in 1996, and how many people actually have two parents living together? And I just think it's something we might want to think about.
Well, there's two things in that. One is the attempted invisibility, the attempt to make invisible our own families when they say, well, marriage ought to be for raising children.
Well, I was stunned by that there was a conception that Mr. Knight put out there in support of his bill that the reason for marriage is to raise children. And the logical conclusion from his explanation about why he supported this amendment is that infertile straight couples can't get married.
Or elderly couples.
Or right. You know, if women have reached the age of menopause, they don't have a right to marry. If men are infertile, they don't have a right to marry. And I think it really is this mythology of what marriage is about.
And the flip side of it, that we don't have children.
Exactly. And the whole marriage issue, I had just a heart-wrenching case. A woman called me fairly recently, had raised two children. She's a non-biological parent. She and her lover broke up, and now she doesn't even have visitation rights. And under California law, there is very little that she can do. Because she was the one who actually did most of the child raising, we might be able to make some sort of argument. But it's just heart-wrenching. These kids have called her mom for 10 years, and now she has no rights whatsoever. So, you know, marriage is about a lot more than just the marriage benefits of, you know, tax breaks, and it really affects people's lives.
It serves the opposition well to demonize us as, you know, not as child molesters, not child raisers. But so many lesbians have been married or have been in heterosexual relationships and have children, or they choose to have children now by alternative insemination, or, I mean, there's such a variety of families. It seems to be very threatening to a small group of people, as though, it's what you said really, Carmel, we're going to draw a little circle around the word marriage, and then we're going to say if they get in the circle, it somehow diminishes the wonderfulness of this. Why? Because it's not just kept to us, and we'll have one less tool to demonize them with.
Well, I think it's also the trivialization of our relationships, that our relationships are not as long-lasting or as meaningful, or we as couples do not have to go through the same things that heterosexual couples go through. And it really is a vicious circle, because that's how we're viewed. We're not allowed to get married, and because we're not allowed to get married, our relationships are not viewed as seriously as they should be. But I think Carmela is right in terms of the mythology here. I think there are certain areas that for people it's much more threatening, and the surveys you've talked about show that. When it comes to employment discrimination, large numbers of people are opposed to that. They don't like employment discrimination. When it comes to gays and lesbians marrying, or being allowed to serve in the military, or have children or raise children, that becomes much more threatening for some reason to people. Somehow it seems to either diminish what they're doing, or it intrudes in some way, at least in their minds, with some protected right they have. And I really can't get a handle on it. I don't know if you've encountered that in any litigation around child custody.
Yeah, well, I'd say the state of California is a perfect example. We're one of only 9 states that have protection against discrimination based on being lesbian or gay. And yet, there are no visitation rights that this woman has a legal right to for her children. And somehow once it gets into the area of marriage and family, all bets are off.
Well, I always envision it kind of like, though I was working too young to become a Girl Scout, it's sort of like you can have all these badges, and we're going to tell you that you don't qualify for those badges just by virtue of who you are, so that I'm going to be the one, and I get to say who gets the badges. You know, I can get married. I have a preference in custody. I have a preference in this job, etc., etc. And somehow society, as it moves along on a more progressive track, and it always does, says first, I don't think it's fair if somebody can do the job that they don't get it. Now, there's still a lot of people, you create a mythology about who can't do the job.
Right.
I mean, every disfavored minority is referred to either as stupid or lazy or some characterization about shiftless. And with us, they don't say we're stupid, lazy, or shiftless. They say we're disruptive in the workplace when we come out. Why are we disruptive? Because they're going to beat us up, and it just takes too much time away from work, I guess. I mean, it's just what happened to your police officer.
Mm-hmm. Right.
It's so oppressive. Well, it is disruptive, but it's homophobia that's disruptive, not necessarily the fact that we're there.
It's people reacting to us who are uncomfortable being around openly gay and lesbian people, who are threatened by us. Those are the ones who cause the disruption.
Well, and that's really what has happened, I think, with all minorities. I mean, we've blamed all our problems on illegal immigrants this year.
Mm-hmm.
In other years, we blame all our problems. Now it's affirmative action. Now we're going to blame all of our problems on affirmative action. Reminds me of a sort of a magician who's doing all this chicanery over here and says, you know, don't look at that hand. I mean, look at this hand. These are the people to blame. And we're certainly one of the groups. So what do you see for the future in terms of our community and the law? Any prognostications?
Well, I guess as the law professor, I'll take it. And I just reemphasize what I've said before. I think one thing is definitely clear in terms of our numbers in the gay and lesbian community, our visibility in the gay and lesbian community, it's just going to continue to grow. I mean, based on the students I see and the faculty members who are teaching our issues in their classes, even if they're not gay and lesbian themselves, our issues are in the forefront of their classes, and they're talking about our issues, which wasn't the case as much when I was in law school, and I'm sure when you were in law school as well. And I think in terms of the legal battles, we're going to continue to lose some. We're going to also win some. I think the Colorado case, what has been reported about the oral argument is very optimistic, although I wasn't optimistic just based on the written material. The questions seem to be such that it appears the justices really get it and understand that what Amendment 2 does would allow us to be excluded from emergency rooms. There'd be nothing we could do about it. We couldn't even go to our local city council and say, protect us from this discrimination. So I think that there are going to be some significant victories, and I think Hawaii is going to be a victory. I think we're going to see the Hawaii court say, you're right, there is no justification for this discrimination. What happens in other states, that's going to be a big political battle for many years to come.
Well, it was a big political battle based on race, too. I mean, just every single state had to make its own decision for itself. It looks pretty good in terms of employment discrimination, though, don't you think?
I guess it's called ENDA, Employment something something. The good
Employment Non-Discrimination Act.
The good news is that it did move this session, despite the Republican majority. The bad news is God only knows when it'll actually be passed. So I think we really need to continue to focus on that issue, and that it's not a sure thing. Even that issue is not a sure thing.
Do you see any new or different areas sort of coming along? I mean, I think people think about employment. We're now talking a lot about marriage, though we weren't. We were willing to settle for domestic partnerships, you know, just a year ago, and now we think, well, maybe not. You know, maybe we should go for what other people might call the real thing. Do you see any other issues?
Well, marriage entails a lot of other responsibilities, and I think our community has to get up to speed on that as well. if marriage goes forward, then what are you going to do when there's separations? What are you going to do with child custody issues? What are you going to do about, we as a community are going to be having to face all of the issues that are currently faced in heterosexual marriages, and certainly we're already facing them to some degree with split up of relationships and how do you divide the property. It's going to raise, I think, some unique issues legally. And it's going to, I think, raise some questions in our own community about maybe we need to modify the current rules with respect to dividing property. Maybe we need to weigh in and say these rules aren't really fair for the partner who is the breadwinner or who isn't the breadwinner in the relationship.
Well, we might have to grow up a little more, too. It's a little scary for our community. Well, this has been wonderful. I know it doesn't seem like we've been talking for an hour, but we have, and we've just about run out of time. So I want to thank you, Taylor and John and Carmel, very, very much. The Lambda Legal Defense and Education Fund, which is based in New York City, is doing sort of the yeoman's job on the marriage issue, and information is available from them. Taylor's at the ACLU here in Southern California, but don't call her directly with your thousands of cases. There are lots of other places that you can call, but certainly you'll get information on anything you need. Most important, be politically aware. When you vote, make sure you're voting for someone who's already demonstrated that they're on the side of our community. Whatever you do, get used to it.